Condition from April, my lord.
Stay now. Your friend has also come out from the jail.
Okay, how can the lady execute a power of attorney to deal with a property which is standing in the name of the company?
Director.
Correct. But the director has no right to execute a power of attorney to deal with the property of the company until unless the director has a board resolution or is a...
Where, my lord, this agreement, my lord, is executed.
Correct.
And, my lord, 44 lakhs in cash is paid and 11 lakhs by way of check to, my lord, the middleman. My lord, we have enclosed that, my lord, in our application for vacating for, my lord, a portion of the order which required investigation to be done by CID. Because according to us, my lord, there's not been any fair investigation. Now, my lord, what happens, my lord, there is, my lord, source of funds
has been filed with
my lord, now, my lord, this is, my lord, the story. And, my lord, this is...
And what is the forged court order?
I have not seen it.
You have got a copy of the forged court. Who is the complainant?
Different.
A third party.
Yes, my lord. Yes.
Now, how do you connect this third party to the propounder of...
My lord, I'll tell you, lordship, my lord. My lord, one of the complainant's husbands, my lord, is, my lord, a gentleman, Saif Alam, my lord, who, my lord, even in, my lord, the TI parade, my lord, our cases, my lord, that, my lord, people known to, my lord, Saif Alam, my lord, were made part of the TI parade, which is why we have complained. And our cases, my lord, that's also set up, my lord, and recorded.
Who is this Saif Alam? Saif Alam is the husband of the victim in the rape case.
Manju Agarwal, my lord, who is one of the, my lord, complainants. Nephew and, my lord, Manju Agarwal.
Propounders of
the will.
Manju Agarwal is the propounder of the will.
Correct.
And Saif Alam, how Saif Alam is connected?
And
how Saif Alam is connected to Manju?
My lord, husband of Manju.
Oh, Manju's husband is Saif Alam.
The division bench, my lord, held. My lord, that's, my lord,
and Saif Alam is in the rape case or in this case?
No, not in this case. In this case,
in the rape case.
In the, my lord, it has been found, my lord, by, my lord, the division bench that, my lord, considering the factual matrix, my lord, this is, my lord, there is a connection between the de facto nexus between de facto complainant with the deceased. My lord, there, my lord, anticipatory bail is granted. Now, my lord, in this matter, my lord, there was an anticipatory bail granted to the daughter. My lord, both mother and daughter, my lord, were made, my lord, accused. Daughter, my lord, has got anticipatory bail.
In the other case?
No, in this case.
In this case?
Yes.
In this case, the daughter of Meena Agarwal?
Yes.
Has been granted anticipatory.
Yes.
She hardly any role. Meena is the one who executes the will.
Power of attorney, and my lord, Avni is the person introducing everybody.
Okay. Introduce the mother.
Introduce the mother.
The father.
No. My lord, father's past, my lord.
Husband.
Alleged husband.
No. My lord, the allegation is, my lord, that Meena, my lord, has, my lord, a romantic liaison, my lord, with the middleman.
Okay.
So, my lord, now, my lord, second husband, etc., my lord.
So Meena Agarwal is a close friend of this co-accused middleman, and both of them together negotiate with the complainant, take money on the promise of conveying property, saying that Meena has a power of attorney to deal with the property, and to instill confidence, shows a forged High Court order,
that is it.
and
Correct.
they give money. This is the order.
Yes. And the page thereafter is the injunction order. The original injunction order. And this seems to be the manifestation.
Whether this order is a forged order or not. It doesn't cover the... Yes, Mr. Bandyopadhyay.
Forged order.
Yes, we have seen.
Copy of the forged order, your lordship have seen that?
Yes, it's placed before us.
Yes. 22nd September 2023.
Okay.
Lord, this is the, Lord, the factual position. Now the point remains, Lord. Yogesh Khemka.
Mr. Khemka.
And Yogesh Khemka was in a custody for a considerable period of time.
He's on bail.
The point is this, Lord. When interim bail was granted, that time 467 was not added.
Right.
And when Khemka was also released on bail, that time also 467 was not there.
Very good.
Therefore, my lord, my humble submission would be there, Lord. When the charge sheet was filed by the Baripur police station, 467 was not there.
All right.
Now, my lord, when before justice goes, whatever may be, this case cannot be compared with the case of when the bail, I mean, not the case, when the time it was taken for granting anticipatory bail or granting bail to the Khemka is concerned.
Investigated in a better way than the state local police, right?
Correct, my lord. Initially 467 was there. In the time of the charge sheet, 467 was dropped by the local police.
That
They are
is,
saying on the contrary,
Mr. Bandyopadhyay, that is why the investigation by the superior specialized agency has catered to your concerns in a better way than the local police.
correct, absolutely correct.
All right.
Absolutely. Yes,
What we consider is you are really troubled by certain observations in the grant of interim bail. We will look into that. The comment with regard to overzealousness of the local police to invoke its jurisdiction and registration of FIR is one of the observations which appear to have weighed with the Honorable Single Judge in transferring investigation. Be that as it may, the investigation is presently progressing to the satisfaction of the complainant.
My lord, my lord, CID, my lord, to whom, my lord, the investigation was entrusted. My lord, I have given 3 instances why, my lord, the investigation, my lord, is not fair. We are, my lord, want investigation, but my lord, special investigation team, your lordship's appoint.
All right, we are not inclined to allow your recalling application.
only one fact just I want. Miller, kindly excuse me, Miller.
Yes.
Miller, kindly see, Miller, page 103 of the bail application.
Yes.
Just once your lordship see. They are saying that there he has said, Miller, this is a complaint from Meena Agarwal, GD.
Bandyopadhyay,
Yes, my lord.
was the forged order necessary to transfer the property?
No, forced order was not. Kindly see. When I asked them the question whether the property is out of encumbrances or any other thing, whether that is it.
Is the forced order, is the property custodial legis of the probate court?
Yes. And
Is it-
Justice
21 days.
Background only.
21 days.
21.
It permits even sale. Now the board directs her to only authorize this for.
That we've asked Mr. Mukherjee.
This is where her personal criminal culpability appears.
We agree. And this power of attorney makes it unlikely, but subject to the recital that you show in the agreement for sale, that they would engineer a forged court order to show that we are permitted to deal with it.
Forged court order is for me.
Was executed on 18th May 2023. Subsequently, criminal case was registered. Now, subsequently, criminal case was registered, alleging that the petitioner, her power of attorney holder, Khemka, and others petitioner was arrested in the case. Petitioner was arrested in the case. When was she arrested?
She was arrested on 3rd of April 2024.
On 3rd. Was she arrested prior to filing of charge?
After charge sheet,
Acha. For bail before the Honorable Single Judge, as the offences in the charge sheet were punishable up to, as per roster, petitioner paid for bail before the Honorable Single Judge as offences in the charge sheet were punishable up to 7 years. During hearing, learned senior counsel for the complainant submitted that the FIR was registered under section 467 IPC and the ingredients of the said offense are disclosed in the charge sheet. Accordingly, Honorable Single Judge was pleased to release the matter for want of jurisdiction, and the, yes?
No, subsequently, during further investigation, 467 was added.
Okay. Acha. During the hearing of the bail application, it was brought to the notice of the Honorable Judge that offence under section 467 IPC has been added. Under such circumstances, Honorable Single Judge released the matter, and the same has been placed before this bench. Full stop. It enlarged the appellant on interim bail, observing that the petitioner being a lady and initial charge sheet had been filed, enlarged her on interim bail. Stop. By the self-same order, the investigation of the case was transferred to ADG CID Bhavani Bhavan. Transferred to ADG CID Bhavani Bhavan, who was directed to depute an officer in the rank of inspector in charge, preferably engaged with anti-cheating squad, to conduct further investigation. Stop. Of a purported will propounded by of a purported will propounded in the probate proceeding. He contends another false criminal case was registered, alleging attempt to rape was registered against the petitioner's son, who is presently on bail, who has been enlarged on bail. Full stop. Property, demised property was owned by the company, and cannot be said to be the assets of the deceased, over which injunction order is in force. He also contends the investigation was conducted. He also contends allegation that petitioner did not participate in investigation is wholly false, as the notice under section 41 capital A CRPC was served upon her, was sent to a different address, and she was unaware till warrant of arrest came to be issued. Full stop. Investigation has substantially progressed and initial charge sheet has been filed. Petitioner was in custody for over 3 weeks when she was being released on interim bail. Till date, there is no allegation of misuse of liberty by the petitioner. Co-accused Khemka has been released on bail, which order has been released on bail. Full stop. Accordingly, he submits that bail granted to his client may be confirmed. Per contra, Mr. Bandhopadhyay, senior advocate, submits that the offence has the allegations show the daring nature of the crime. Full stop. Petitioner and his associates forged a court order to give an impression that the property was unencumbered and persuaded the complainant to part with money. He further submits part with money. He further submits. He also refers to the recitals in the deed in the agreement for sale, which gives reference to the forged order. Full stop. The forged order was recovered from the premises, which is in the control and custody of the accused persons. A forged order and other incriminating materials. Full stop. There was videography of that recovery.
Well, pre-search and Milord post-search.
Yes,
Everything is there.
but recovery was not a part of the video.
Recovery also, but Milord, at the time of opening, envelope Milord was recovered. Milord, that was when that was opened. Milord, they were called, and Milord, it was opened.
All right.
There is a disjunct in this.
Disjunct will be seen during trial.
And from the spa bathroom, washroom of the spa.
That's in your control.
Yes.
In a spa, my
Exclusive.
lord. In a spa.
Right.
And first of all, my lord, the officer who procured it or rather brought it or found it, he refused
This is
personal
excess,
charge.
my lord.
B.
All right, that is very well. We will see all this far, which is run by the petitioners, which is run by petitioner and and her associates. Full stop.
Means run by the company, my lord. Company, run by the company, my lord.
Which is under the which is run by the company owned by the petitioner and others. Full stop. A anticipatory bail granted to petitioner's daughter has been assailed before the apex court. Bail order. Khemka was enlarged on bail when offense under section 467 IPC had not been added, and petitioner cannot claim parity on such score. Learned counsel for state produces the opposes the bail prayer. He produces the case diary and other documents relating to investigation. He contends notices under section 91 CRPC was issued upon the petitioner, but she did not personally attend. 91 CRPC was issued. What notice was issued?
Yes, my lord, that is.
How can 91? What documents were you seeking?
Lord,
91 CRPC was, but she did not attend. Full stop. We have considered the materials on. Record. Stop. Crux of the allegation is that the petitioners had manufactured a forged order. Petitioner and others had manufactured a forged court order to give an impression that she was permitted to deal with the assets, to give an impression that she was permitted to deal with the assets of the deceased, and on the strength of the said order, and the complainant was induced to enter into the transaction and pay an initial sum of money. Mr. Mukherjee has brought to our notice that the property in question is not the assets of the deceased, but belongs to a company, of which petitioner is a director. Accordingly, the order injuncting petitioner and other legal heirs in the probate proceeding does not apply to the said property. Does not apply to the said property. On the other hand, Mr. Bandyopadhyay draws our attention to the recital in the agreement for sale, which refers to the forged order, to establish the right of the petitioner to convey the property. Full stop. These issues with regard to the materiality of the forged order may be thrashed out in the course of the trial. It may be thrashed out in the course of the trial. Full stop. May be thrashed out in the course of the trial. It is also argued that the complainant may be thrashed out in the course of the trial. However, it is relevant to note that the forged order, however, it is relevant to note that the forged order has already been recovered, and custodial and continued and remanding the petitioner back to custody for purposes of recovery is not necessary. It is also relevant to note that investigations undertaken by the income tax authorities with regard to the financial capacity of the petition of the complainant does not give an impression that he was in a position to uh, arrange 44 lakhs as earnest money on his own. This on its own, full stop. Though this aspect would not wholly discredit the prosecution case, but requires to be, but the manner in which the complainant is alleged to have handed over a tranche of 44 lakhs in a public eatery requires to be looked into, requires to be inquired into requires to be inquired into during the course of further investigation. Full stop. The other aspect which has been required to be investigated, the other aspect of the requires to be gone into further investigation. Co-accused are on bail. Co-accused Khemka is on bail, and no prayer has been made either at the end of the state or the complainant to cancel his bail after addition of section 467 IPC. Though some submission was made that petitioner did not personally respond to notices under section 91 CRPC, we are apprised that she replied to the said notices and replied to these notices. That apart, notice upon an accused under section 91 CRPC is barred under Article 20, Clause 3 of Constitution. Full stop. On the other hand, petitioner attended the TI parade, attended during TI parade investigation and has rendered, and it is submitted, she is ready and willing to render all assistance to progress in further investigation. Full stop. In such light of the matter, we are of the investigation. Presently, further investigation is progressing. Presently, further investigation is being conducted by a specialized agency. And we are of the opinion that investigating agency. In such light of the matter, we are of the opinion interim bail granted to the petitioner may be confirmed. Stop. On same terms and conditions. Full stop. Presently, investigation is being conducted by the specialized agency. Conducted by the specialized agency in terms of the order passed by this court. Petitioner has prayed for recalling of the order, of the said order. As the further investigation is in, since we are satisfied with the course of further investigation in the matter, we do not consider it prudent to recall, which is in the hands of a specialized agency. We do not consider it prudent to transfer, to recall the earlier order regarding.
Can you withdraw the CRAN, my lord?
Withdraw it, please. Get it up.
Please, man.
Application for bail is allowed. Connected application being not pressed is dismissed.
One request I have. Kindly see inner page 3 of the interim order, my lord. If on bail, petitioner shall not leave the jurisdiction of Calcutta and 24 Pargana South, my lord, without the leave of the learned ACJ. If that may be waived, my lord.
Where do you want to go? Why do you want to go?
But factory is outside that, my lord.
Factory?
But if it may be, but my passport will be with, I mean, with the court, my lord. I'll deposit my passport.
As of now, Steve.
Or maybe in India, my lord.
Why India?